Okay, let's get started. Good evening, everybody. My name is Gordon Hughes, and it's my pleasure to welcome you all to this Davies Collison Cave legal update, one of the series that we are running for the benefit of our clients. This evening's session is going to focus on certain legal issues that have arisen in relation to the COVID-19 pandemic. We've got three sessions this evening. I'm going to start by talking about some privacy issues. I'll be followed by Andrew Sutherland, who's going to talk about electronic signatures and electronic witnessing in an online environment. And Andrew will be followed by a joint presentation from Felicity Dalnagare and Melanie Davey, who will be talking about some temporary changes that have been introduced to Australia's insolvency laws. Feel free to email any questions through to us as we go. I can't promise that time will permit us to respond to all questions, but insofar as we don't, we'll make sure that we email you a response in the next 24 hours or so. So, starting with my topic, as I've said, I'm going to talk about some privacy issues relevant to COVID-19, and in particular I want to talk about privacy issues relating to the collection and handling of contact tracing information by businesses. All of us are by now familiar with the fact that when we attend business premises, whether it be our employer or whether it be some other business, we're often asked to provide details of our name and contact details. We may be required to undergo a temperature check. We may be required to answer some form of a questionnaire regarding symptoms that we've got or symptoms that we've experienced in the past, all in the name of contact tracing, all of which is very responsible on the part of the business. But I want to talk about some of the privacy issues that surround the right of a business to request this information from people attending their premises, and then how they can use that information, what they can and can't do with it. That's going to be the focus of my comments. I will at the very end comment also on some privacy issues relevant to the COVID Safe app. But I'm going to keep those comments very brief because in the current climate, the ongoing relevance of the COVID Safe app is very much up in the air, and I don't want to spend more time than is necessary dealing with that issue. So in relation to privacy, any discussion about privacy requires a fundamental understanding of Australia's privacy framework. And it's a very complex framework. It involves a number of pieces of legislation, both federal and state, which interact. There are various situations where some of those acts don't apply. There are various situations where they overlap. So it's been rather bold on my part to try and reduce all of this to one PowerPoint slide, but there it is. And these are the fundamentals that you need to know. The principal legislation in Australia regulating the collection and handling of personal information, let's just assume for the purposes of this discussion that contact tracing information is personal information. The principal legislation is the Privacy Act, which regulates the handling of personal information in the private sector and in the Commonwealth public sector. And within that Act, there's Schedule 1, which contains 13 principles known as the Australian Privacy Principles, and that sets out, that's basically a guide to everything you need to know in relation to collection and handling information of this nature. The Privacy Act, however, does not extend to state and territory government agencies. For that reason, most states and territories, but not all, have enacted their own privacy and data protection laws. Those laws regulate the handling of public sector information in those states and territories. But Western Australia and South Australia haven't followed suit, don't have laws of that nature, so that just creates a bit of a complication. On top of all of that, some states, some jurisdictions, but not all, have health records legislation. And that legislation regulates the handling of personal information in the form of health information. And again, for the purposes of this discussion, let's just assume that information provided in connection with contact tracing, such as records of your temperature or records of your symptoms, is health information. And that health records legislation contains health privacy principles, which for all intents and purposes have the same effect as the Australian privacy principles. But that health records legislation only applies in 3 jurisdictions: Victoria, New South Wales and the ACT. So it's complicated. In terms of the Australian privacy principles, which are the most important part of the framework, there are 3 principles that are relevant for the purposes of this discussion: Principles 3, 6 and 11. Australian Privacy Principle 3 essentially says that a business is allowed to collect personal information so long as it's relevant to its business. It's got to bear some relevance to your business before you're allowed to collect it. And if it's sensitive information, and that includes health information, it also requires the consent of the individual before it can be collected. Australian Privacy Principle 6, which is a very important principle, says that once collected, personal information can only be used in connection with the reason that it was originally collected for. You can't collect personal information ostensibly for one purpose and then use it for another purpose. An exception to that is if a law is passed which allows you to use it for some other purpose. Australian Privacy Principle 11 is divided into 2 parts. 11.1 says that if you have collected personal information, like contact tracing information, it must be kept secure and free from unauthorised access. And 11.2 importantly says that once you've collected personal information, like contact tracing information, you can only keep it for so long as it's relevant to the original purpose of collection. You can't keep it indefinitely. And the rule of thumb for contact tracing information is that it's no longer relevant after 28 days. So far, I think those principles are all pretty straightforward and most people don't have much difficulty grasping how that applies to their business. But there are complications. The first complication is the so-called employee record exemption under Section 7, capital B of the Privacy Act. And put simply, this says that employee records are exempt from regulation under the Privacy Act. So what that means is that whilst we are concerned about the privacy implications of collecting personal contact tracing information from individuals, if it's a case of an employer collecting that information from an employee, the handling of that information by the employer is not regulated by the Privacy Act. Another exemption is the small business exemption. Small businesses are businesses which have an annual turnover of less than $3 million. They are exempt from regulation under the Privacy Act. So personal information in the form of contact tracing information collected by a business with an annual turnover of less than $3 million will not be regulated by the Privacy Act. But then there's another complication, that's this health records legislation that I mentioned before. And it only applies in Victoria, New South Wales and the ACT. But if contact tracing information incorporates health information, temperature checks, symptoms, whatever, then, and it's collected in one of those 3 jurisdictions that I mentioned, then it will be subject to the health records legislation and the health privacy principles contained in that legislation, which are the same as, for the purposes of this discussion, as the Australian privacy principles. There are more complications. Most of the privacy principles relevantly create an exception where an Australian law says that they can do something with personal information which they otherwise wouldn't be permitted to do under the principles. What we've seen in the last 3 months, of course, is a plethora of COVID-19 specific laws, and some of these relate to the collection and handling of personal information. Information, for example, governing the collection of information of people who attend restaurants. That may create specific rules requiring the collection of personal information and authorising the disclosure of that information to the Department of Health, for example. But even that is not as simple as it sounds, because COVID-19 specific laws aren't all neatly enshrined in statutes. A lot of them are delegated legislation. For example, in Victoria, the Chief Medical Officer can issue directions under the Public Health and Wellbeing Act, and those directions have statutory force. And those directions are issued at the moment at the rate of about one every 1 or 2 weeks. And even if you follow those directions, they're not that easy to follow, even if you read them closely, because some of them say, for example, the last set of directions issued in relation to restaurants said it's mandatory to follow government recommendations in relation to the collection of information relevant to restaurants. What's the government recommendation can be pretty hard to determine. So that's an added complication in working out what you can and can't do with personal information. And there's more. I've already said that employee information is effectively exempt from the Privacy Act. But the question of who is an employee and who is a contractor is not always that clear. As any employment lawyer will tell you, there have been countless cases where courts have been confronted with a situation where a person is ostensibly classified by a business as an independent contractor, but the court has found that in reality they are an employee. So you have to navigate that distinction. And then there's further complications arising out of occupational health and safety legislation. It's one thing to be conscious and appropriately conscious of not exceeding the limits of privacy restrictions when handling personal information and collecting personal information. But at the same time, an employer has to be cognizant of its obligations under the occupational health and safety legislation that applies in this particular state to create and maintain a safe working environment. And creating and maintaining a safe working environment may well necessitate a stringent approach to ensuring that persons exhibiting relevant symptoms, for example, are not allowed into the workplace. And the final complication is that it's one thing to talk about handling and disclosing personal information only in compliance with privacy laws and observing that privacy laws don't always apply for various reasons due to various exemptions. There is also concurrently obligations that may arise under confidentiality obligations. So a person can provide information to a business when they enter the premises, and the business may or may not have a right to handle that information in a certain way in accordance with privacy laws, but that information may well be classified as having been handed over under conditions of confidentiality, and equitable obligations constraining the disclosure of that information may also apply. So collecting and using and disclosing contact tracing information collected in this way is not all that simple. So with that in mind, I've put together a checklist, and in the interests of time, I'm not going to step through this checklist, which goes through about 3 pages, but every one of you will have a copy of these slides, and I do urge you to use this checklist. It's a series of steps which have to be gone through before your business can confidently know whether it can collect contact tracing information, what sort of information it can collect, and what it can do with it. Leaving that aspect there, let me just now round off by talking very briefly about the COVID safe application. Now, as I say, I sense that the future of the app is very much under a cloud at the moment. And so I don't want to spend more time than is necessary talking about it, but I'll just mention a couple of key features. When this initiative was announced in April 2020, there was a lot of public concern expressed about the privacy implications both of registration data, that is someone's name and contact details that you have to enter when you download the app, and also the handling of location information, which people were particularly sensitive about. And so the government brought into effect on the 15th of May amendments to the Privacy Act to reassure the public and to encourage downloading that very stringent controls would apply to how COVID safe related information could be used. It introduced a new Part 8A into the Privacy Act, and Part A contains numerous very stringent restrictions on how that information can be used, and it's emphasised in 10 different ways that the information can only be used for the purposes of contact tracing. It can't be accessed by law enforcement authorities. It can't be accessed by government for any purpose other than specifically and directly in relation to contact tracing, and it will all be deleted on a rolling basis after 21 days. There's just one thing I want to mention. This is the final point I'm going to make. One thing I'll mention in relation to COVID Safe App, which is relevant to what we've been talking about in terms of greeting people at the door and asking them for information. The COVID Safe amendments to the Privacy Act include a section 94H. And 94H says that a person can't be coerced or obliged into downloading and installing the application. And what that means, for example, is that an overzealous business effectively can't say to a visitor, you're only allowed in the door if you first download the COVID Safe app. Now, the wording of that prohibition is open to debate, which I won't go into now. I'm just flagging it as an issue which businesses need to keep in mind before they become overzealous in introducing that sort of restriction on what people can, can't and should do. That's what I'm going to comment on at this stage. We're moving through tonight's program at a fairly rapid pace. Please feel free to email any questions if you'd like to. If time permits at the end of this 60-minute session, I and the other speakers in relation to their sessions will happily answer any questions. To the extent that we don't get time to reach them, we'll email you back. I'm going to pause at this point. I'm going to hand over to Andrew.
Thanks, Gordon. Hopefully everyone can see my slides. So hi, I'm Andrew Sutherland. I'm a Senior Associate in DCC's Melbourne office. And today I'll be presenting on both my own behalf and also on behalf of Lachlan Sadler, and thank you to Lachlan for his assistance with this presentation. I'll discuss electronic execution, which has been around for many years, but has become increasingly important recently as many businesses have needed to implement remote working arrangements as a result of COVID-19. I'll also discuss remote witnessing, which was recently introduced in a number of states and in the ACT in response to the more limited ability of signatories to meet with witnesses in person. I'll firstly briefly address some background matters in relation to the execution and witnessing of agreements and deeds at common law. I'll touch on the Electronic Transactions Acts, or ETAs. I'll then cover the temporary COVID-19 measures and conclude with a couple of practical examples.
My name is Melanie Davey. I'm a lawyer in our corporate, commercial and tax team. My co-presenter, Felicity Delanagaro, is also part of that team, and we'll be presenting today on the temporary changes to insolvency laws that have been enacted by Schedule 12 of the Coronavirus Economic Response Package Omnibus Act. So I guess more specifically, we're going to be talking about those changes in light of the changes it's made to the Corporations Act, and that specifically relates to insolvent trading and statutory demands. So I won't labour too much on this because I understand legislation is not particularly interesting, but the relevant legislation is the Coronavirus Economic Response Package Omnibus Act. I'll just refer to it as the Act throughout this presentation. And this Act was one of many legislative instruments that's been introduced to provide temporary relief to businesses during the coronavirus pandemic. Obviously, as a very dynamic and changing landscape, it's something that's required quite a lot of legislative change, temporary legislative change that is, and this is one of those responses. So specifically, Schedule 12 was introduced to allow really directors a little bit of flexibility to steer their businesses through the challenges presented by COVID-19. And it allows them to operate more specifically in a period where their company may be facing challenges of liquidity or may even be questionably insolvent. The provisions that we're going to talk about came into effect or became effective the day after royal assent was granted. So the relevant date that we're going to be talking about is the 25th of March of this year. And that's relevant because a lot of these provisions refer to a 6-month period. And when we think about the 6-month period, we're thinking of 6 months from the date 25th of March 2020. So as I discussed before, we're going to be discussing the temporary changes that have been made to the provisions of the Corporations Act relating to insolvent trading and statutory demands. It is, I think, important to flag that there have been some temporary changes also made to the Bankruptcy Act. Obviously, that relates to individual bankruptcy and it kind of goes beyond the scope of what we're going to be presenting today. But just for your background, the changes to the Bankruptcy Act broadly relate to bankruptcy proceedings issued or declared after the 25th of March. And the threshold for initiating bankruptcy proceedings has been increased from $5,000 to $20,000. The response time for debtors to respond to bankruptcy notices has also been increased from 21 days to 6 months. So there's just a little bit, I guess, of a bit of leeway in relation to solvency issues in general, both in the corporations aspect as well as the individual. But leaving that aside, we'll go on to speak about insolvent trading. And I guess before we jump into those slides, it's important to remember that in the context of insolvent trading, the temporary relief that's provided under this Act is sort of intended to extend some of the reliefs that are already available under that Act. So specifically the existing safe harbour provisions, it doesn't replace them or amend them, it just extends them for the 6-month period. I think also it's just quite obvious, but I need to mention that the relief provided under the Act is intended to be temporary and it's only intended to run for 6 months from that commencement date. However, there is another schedule in the Act, which is Schedule 16, and that schedule allows for the minister responsible for an Act to extend the sunset date of that Act for another 6 months from the original sunset date. So it is possible that the provisions, the temporary relief that has been provided here could be extended for a further time, but as at the date of this presentation, we don't have any further information on that. So I think it's just something that is going to be a bit of a wait and see. So as I flagged before, I'll briefly touch on first the changes to insolvent trading. So this relates to section 588G of the Corporations Act. And just, I guess, for your background, the general proposition is that directors are generally protected from personal liability for debts incurred by a company. However, because of section 588G, the directors do have a duty to prevent insolvent trading. And because of that duty, directors may incur personal liability for debts incurred by the company, during which time the company is found to be insolvent. And so obviously, in light of the coronavirus pandemic, directors have been forced to think about the liquidity of their companies in a kind of a different way, and probably a little bit more intensely. And in some circumstances, it may be that a company needs to go into what's been referred to in a lot of commentary as hibernation in order to survive the coronavirus pandemic and the restrictions that have come along with that. And so this legislation was introduced really to allow companies to, I guess, hibernate and be quote unquote saved from falling into insolvency or having to go into external administration as a result of the extreme economic pressure that has come along with some of these restrictions and other aspects of the coronavirus pandemic more generally. Now, the Corporations Act already contains safe harbour provisions. These were introduced in September 2017. And those provisions, I won't go into them for this presentation, but they do set out a list of criteria under which directors are protected from personal liability in circumstances where the company's solvency may be questionable. And so it's just providing directors with a little bit of leeway in terms of their ability to make perhaps less risk-averse decisions. And this temporary relief just extends that protection. So in light of the specific temporary relief provided by this Act, directors are enjoy a bit of protection from personal liabilities for debts that meet the three criteria I've listed there on the slide. So the debt must be incurred in the ordinary course of the business, it must be incurred during the 6-month period, and it must be incurred before the appointment of an administrator or a liquidator. Now, obviously the last two of those provisions are pretty straightforward. It's quite simple to work out whether or not your debt is going to fit into those two. The first one is a little bit more contentious, and the explanatory material, it doesn't really, it provides a few examples, but it's not wholly illuminating. Basically what it says is that a debt is incurred in the ordinary course of business if that debt is necessary to facilitate the continuation of the business during the 6-month period. And some examples that have been provided in the explanatory material are, for example, a debt incurred in order to continue paying employees during the coronavirus, well, during the 6-month period, but that probably accords with a lot of the lockdowns that we've had. Or, for example, moving business operations online instead of perhaps a more ordinary face-to-face method. But again, this is a point of contention, and it's something that Felicity will touch on later. A holding company can also rely on the safe harbour temporary measures. So the directors can rely on that, directors being the directors in the holding company, but they have to be satisfied that the debt incurred at the subsidiary level is in fact going to satisfy all of those three requirements. So that's just something to keep in mind. Finally, I'll just touch on briefly what remains applicable in terms of directors' duties. So just because directors are enjoying perhaps a little bit broader temporary relief from personal liability for debts incurred, I think it's obvious, but it needs to be repeated, that the safe harbour doesn't extinguish debts incurred during this period. So directors need to be cognizant that debts will continue to apply after the temporary relief ends. And the company, after that relief ends, must return to solvent trading unless it can otherwise, I guess, the directors can otherwise satisfy the existing safe harbour provisions. So it's just something to be aware of, that it's not, I guess, I think it's obvious, but it's not a license to rack up a huge amount of debt, which may be tempting, I guess, when the company is in significant financial distress. Directors also need to be aware that the temporary relief doesn't extinguish any criminal penalties associated with dishonest insolvent trading. And lastly, something to always be aware of is that directors need to continually be actively managing and engaging with the issues of their company during this time. So if we're incurring debts as a director and we're putting aside the issue of the personal liability for debts, we still need to be thinking about our other obligations, both enshrined in legislation and our fiduciary duties. So that may be exercising carrying out their duties as a director with the due skill and diligence, in good faith, in the best interests of the company, for proper purpose, not misusing their position to gain advantage or cause detriment to the corporation, and avoiding conflicts of interest, for example. And there is a huge suite of fiduciary duties as well that directors need to be cognizant of. So they're obviously not impacted at all by the temporary changes. Thanks to the Act. So we're going to move on to statutory demands. I'll hand over to Felicity for that.
Thanks, Melanie. I'm Felicity Dallanagari. I'm a Senior Associate in the Commercial, Corporate and Tax Group of DCC Law. I'm going to talk firstly about statutory demands and then secondly about some uncertain areas in relation to this temporary relief. So Schedule 12 of the Omnibus Act introduces temporary relief in relation to the statutory demand regime under the Corporations Act. A statutory demand is a formal written demand made by a creditor under Section 459E of the Corporations Act. It's well established that as a matter of public policy, a statutory demand should not be used as a mere debt collection tool or as a method of applying pressure to debtors to pay their debts. However, they're commonly used as a last resort attempt to recover an unpaid debt from a debtor company, particularly after debt recovery mechanisms such as letters of demand have been unsuccessful. A debtor who fails to respond to a statutory demand within the prescribed time will be presumed to be insolvent, and the creditor who served the statutory demand can apply to the court to have that debtor company wound up in insolvency. So what does the Omnibus Act do? With effect from the 25th of March 2020, it increases the statutory minimum threshold debt amount, which forms the basis of the statutory demand, from $2,000 to $20,000. And it also increases the prescribed time within which a debtor must respond to a statutory demand, from 21 days from the date of service of the demand to 6 months from the date of service. So ultimately, that means that the creditor will have to wait longer for payment of the debt and will have to wait longer before they're able to apply to the court to have the debtor company wound up in insolvency should the debt not be paid. Obviously, the intention is to provide companies with time to deal with financial hardship without the threat of being wound up. And this may particularly assist small to medium enterprise who are not typically taking on large debts from multiple creditors. It's important to note that other methods of winding up, for example, where winding up is sought by ASIC, is not affected by the temporary changes. Moving on to some potential issues and uncertainties in relation to the temporary relief. Firstly, as Melanie mentioned earlier, the meaning of ordinary course of business requires some consideration, and there's still remaining some uncertainty there. So COVID-19 itself presents situations where businesses cannot be conducted in the ordinary course. Directors are forced to think about ways to conduct their businesses in new ways in order to survive. So it's important to keep in mind that any debts that are incurred during this period must be necessary to facilitate the continuation of the business during that 6-month temporary relief period. It's the directors who are ultimately responsible for proving that the debt was incurred in the ordinary course if that debt's ever questioned, by way of example in litigation or a later insolvency. So it's important that directors take steps to keep good written records of the debts that they're incurring, as well as explanations as to why the debt will facilitate the continuation of the business during the 6-month relief period. The second issue I want to consider is whether the temporary relief will be enough. The provisions undoubtedly assist businesses who are in financial distress because of the unpredictable landscape of COVID-19, particularly by giving them more time to develop a contingency plan and to consider the future of the company. However, the temporary relief, whether or not it actually does enough, is questionable. At the end of the 6-month period, directors need to ensure that their company can return to solvent trading in order to protect themselves, which may not always be possible. So it would be prudent for directors to ensure, where possible, that they're only incurring debts during this temporary relief period that also fit within the requirements of the pre-existing safe harbour regime under the Corporations Act. They need to be realistic about the ability of their business to survive COVID-19, and in some instances this may not be feasible. The temporary relief provisions will best serve companies who are able to bounce back once the relief period ends. So in order to ensure survival, directors need to think carefully about their recovery plans, which may include restructures, refinancing, capital raising, and better credit management practices. The third consideration is that the temporary measures introduced in relation to statutory demands have removed an efficient and cost-effective last resort method of recovering unpaid debts. However, the Treasury argues that creditors are not disadvantaged by the temporary relief regime because they still have other debt recovery mechanisms available to them through the courts. The fourth comment that I wanted to make is that there's provision in the Omnibus Act for regulations to be prescribed, specifying circumstances where the temporary safe harbour relief will not apply. At this stage, no regulations have been passed on that point. So in that regard, the safe harbour relief remains somewhat uncertain. An important fifth consideration is, what can I do as a creditor to ensure that I'm receiving payment of my debts efficiently? So creditors should consider their trading terms and perhaps consider requiring larger upfront payments or deposits to mitigate some of their risks. They should also consider whether their trading terms permit the recovery of goods in instances of ongoing non-payment by a debtor. They should be carefully monitoring their debtor list to ensure that they don't outlay goods or services where non-payment is becoming a trend. And it's important for creditors to be aware that there may be a heightened risk of voidable transactions where debtors are continuing to trade in reliance of the temporary relief provisions, but are actually insolvent. The final point that I wanted to make is it's important for creditors to ensure that they're correctly registering their PPSR securities, particularly at this point in time. It's important that PPSR registrations are recorded on time and without defects. So for example, you need to ensure that you're using the proper entity identifier to have a valid PPSR registration. It's also important to keep in mind that the PPSR is a notice board of security interests only, and that bank debt will almost always be prioritised over PPSR registrations in a liquidation. I finally wanted to mention two other forms of relief that may be available to businesses in the context of COVID-19. Firstly, the Treasurer has been granted a temporary power to relieve specified classes of companies from their obligations under the Corporations Act or regulations, either by exempting or modifying statutory obligations insofar as they apply to that specified class. This form of relief can only be granted for a maximum 6-month period. Secondly, the ATO has issued a media release relating to COVID-19 support measures, which encourages businesses to get in touch with the ATO to discuss relief options. The ATO has highlighted some examples of relief options that might be available, and those include deferrals of payments, shorter time for GST refunds, and payment plan options for companies that are in financial distress. So that concludes mine and Melanie's presentation. As Gordon mentioned at the start, feel free to reach out to us if you have any questions, comments, or require any further assistance in relation to the topics that we've discussed by email. Our contact details are included in the event invitation that you've received. So I'll hand over to Andrew.
Thank you, Felicity. So as I was mentioning, apologies about those technical issues. I'll firstly address some background matters in relation to the execution and witnessing of agreements and deeds at common law. I'll touch on the ETAs, and then I'll cover the temporary COVID-19 measures. So by way of background, at common law, there is no requirement that agreements must be signed. Any requirement that an agreement must be signed arises from legislation. Electronic signatures in relation to agreements have been recognised at common law for many years, and the courts have generally broadly interpreted what amounts to a signature. The comment on this slide from Justice Popplewell illustrates the key aspects of a signature. It is the name or mark of a person which is written or otherwise affixed with the intention of authenticating a document as being binding on a signatory. In a relatively recent New South Wales Supreme Court case, Justice Harrison found that typing a name in an email constituted a signature, in stating quite strongly, Mr. Stewart typed his name on the foot of the email. He signed it by doing so. It would be an almost lethal assault on common sense to take any other view. The key point about deeds in this context is that the requirement at common law that deeds be made of paper, parchment, or vellum. In other words, deeds have traditionally always been physical things as opposed to purely electronic files. In this context, best practice is to proceed on the basis that the common law paper, parchment, or vellum requirement continues to apply. As a result, to ensure that a deed is valid and enforceable as a deed at common law, it should be printed on paper and signed with formal signatures in wet ink. This slide outlines the general position in relation to witnessing agreements and deeds that are executed by individuals, which includes attorneys acting on behalf of Australian companies and Australian companies. Particular legislative witnessing requirements may apply in different contexts. Witnessing is not required for agreements executed by individuals and by Australian companies other than by common seal. Witnessing is also not required for deeds executed in Victoria by individuals. Witnessing is required for deeds executed outside Victoria by individuals, including attorneys, and for agreements and deeds executed by Australian companies by common seal. Even if not legally required, witnessing is still best practice for governance reasons and because doing so helps to prove a party's execution if there is ever a dispute about that. Certain documents may have special witnessing requirements arising from legislation. For example, under the Powers of Attorney Act 2014 in Victoria, an enduring power of attorney must be witnessed by 2 witnesses. To witness a document, absent the temporary measures in a number of states and the ACT, which I'll come to in a moment, the witness must be physically present at the time of execution. The witness should confirm the identity of the person signing. The witness must observe the act of execution to which he or she attests. The witness should confirm the identity of the signatories. And if the signatory is signing on behalf of another party, the witness should confirm the basis upon which the witness is doing so. And finally, the witness must sign at the same time. Moving to the ETAs now. Broadly speaking, the purpose of this legislation, which exists at both the Commonwealth and state levels, is to do away with physical documents. Two key provisions of the Commonwealth ETA are sections 8 and 10. Section 8 validates a transaction which would otherwise be invalid for the reason that it took place by electronic communication. Section 10 concerns signatures. It provides that a requirement for a signature under a law of the Commonwealth can be met in relation to an electronic communication if three requirements are met. Firstly, a method must be used to identify the person signing and to indicate their consent. Secondly, the method must be as reliable as is appropriate in the circumstances. And thirdly, the receiving party must have consented to the method used, which can be achieved by inserting an appropriate clause into the document. The laws that are exempt from the Commonwealth ETA are listed in Schedule 1 to the regulations. General exemptions include the Corporations Act. As a result, if a company executes a document electronically pursuant to Section 127, the company cannot rely on the Commonwealth ETA, and the common law will apply. In other words, due to this exemption, the normal or default position, absent the temporary measures, is that if a company executes an agreement electronically pursuant to Section 127, and the effect of an applicable Commonwealth law is that the agreement is invalid because it was executed in that way, the Commonwealth ETA will not cure that defect and validate the transaction. In other words, the agreement would be invalid. A company could still execute an agreement electronically pursuant to Section 127, but it would carry the risk that the agreement may be invalid for that reason. Other exceptions can include documents that need to be witnessed, powers of attorney, and wills. In relation to deeds, the key point is that best practice is to assume that the ETAs do not override the paper, parchment, or vellum requirement at common law. As a result, despite the ETAs, best practice is to print deeds out on paper and sign them in wet ink. Commentary about these issues by Dick and Loxton notes that the paper, parchment, or vellum requirement has not been examined judicially for centuries. Loxton refers to texts that explain the basis of the common law rule originally was the relative difficulty of writings on paper or parchment being vitiated, altered, or corrupted when compared to wood, cloth, or stone, and that wood or stone may be more durable and linen less liable to erasures, but writing on paper and parchment unites in itself more perfectly than any other way both of those desirable qualities. He makes the point that technology has obviously moved on since the 17th and 18th centuries, and that the common law should catch up. I'm sure many people have some sympathy for that point of view. However, the position is, as I just mentioned. As a result, if a deed which is purely electronic may be invalid and unenforceable, unless it can be enforced as an agreement. If it can't be enforced as an agreement, such as where there is no consideration, it may not be valid or enforceable at all. Another point Loxton makes is that even if the ETAs do override the paper, parchment, or vellum requirement, that does not necessarily mean that a purely electronic deed will be preserved as a deed. That is because the ETAs only validate what is otherwise invalid. So if a transaction which is effected by an electronic document which purports to be an electronic deed can be validated as an electronic agreement, the ETAs won't necessarily preserve the document as a deed because the transaction could be enforced as an agreement instead. Turning now to the temporary COVID-19 measures. The key point about these measures is that they override the paper, parchment or vellum requirement for deeds executed by Australian companies and by individuals, including attorneys, in Victoria, New South Wales and Queensland. And they also allow for remote witnessing. For Australian companies, the key temporary measure is the Commonwealth Corporations Determination. The determination is intended to give certainty that a document can be electronically executed under Section 127, and that if it is, the Section 129 statutory assumptions will be available. The company's signatories do not need to sign the same physical document. The document could be signed and scanned by the first signatory and then printed and signed by the second signatory. Or separate electronic signatures could be applied to fully electronic versions of the document. So split execution is permitted. The document must, however, be a complete copy of the entire contents of the document, not just the execution pages. The requirements under the determination mirror the requirements under the Commonwealth ETA, which I mentioned earlier. In relation to the Federal Court, which will be discussed during our next webinar, the Court is currently accepting electronically signed affidavits and even unsworn affidavits on the basis that they will be sworn or affirmed if required at a later date. In Victoria, the temporary measures provide that deeds, being deeds executed by individuals, as well as mortgages, wills, powers of attorney, stat decks and affidavits can all be electronically executed and remotely witnessed. The remote witnessing must be done via an audio-visual link, such as Zoom or Skype, and the witness must write a statement indicating that the document was witnessed remotely in accordance with the regulations. Consent of the other party is not required. The Victorian measures are currently set to expire on 24 October 2020. In New South Wales, deeds can be electronically signed and remote witnessed. The signature must abide by the New South Wales ETA requirements or the common law. Wills, powers of attorney, stat decks and affidavits can also be remotely witnessed. These temporary measures are currently set to expire on 22 October 2020. And in Queensland, the regulations provide that deeds, mortgages, stat decks and affidavits can be signed electronically. Wills, powers of attorney, stat decks and affidavits can also be remotely witnessed. Deeds and mortgages do not need to be witnessed provided certain requirements are met. And these measures are currently set to expire on the 31st of December 2020. The ACT has made similar regulations. Other states have not yet introduced any temporary regulations, and therefore the default position applies in those states. Some states have passed laws allowing them to make regulations, but have not yet done so. Turning to some practical examples. On this slide, we consider how an individual could execute a deed in New South Wales. Under the temporary measures, the deed can be electronically executed and remote witnessed. First, set up an AV link between the signatory and the witness. The witness should confirm the signatory's identity. Whilst displaying the document on the screen, the signatory should share his or her screen with the witness. The witness should observe the signatory insert his or her signature into the document. The signatory should then send the executed document to the witness. The witness should review the document and satisfy themselves that it is the same document and then complete the required details. On this slide, we consider the execution of an agreement by a company. As noted on the slide, the normal or default position, as I've mentioned, is that companies cannot execute agreements electronically pursuant to Section 127 and rely on the Commonwealth ETA to validate the agreement if it would otherwise be invalid because it was executed electronically. Under the temporary measures, however, as I've mentioned, the situation is that companies can execute agreements electronically pursuant to Section 127. The determination clarifies that an agreement executed in that way will be valid and enforceable. In relation to the consent requirement under the ETAs, the agreement should include a clause stating that the parties agree that the document can be executed with electronic signatures in electronic counterparts, and the clause should identify the method which will be used for that purpose. The directors or a director and a secretary of one company should execute the document using their electronic signatures in accordance with Section 127. The signed document could then be sent to the other party. The other party could do the same in relation to the same copy or in relation to their own counterpart using the same method. This slide summarises the current general position in relation to agreements and deeds executed by Australian companies and individuals, both pre-COVID-19 and under the temporary COVID-19 measures. Here are key takeaways. When determining whether a document can be electronically signed and/or remote witnessed, consider the applicable jurisdiction to work out which law will apply, the type of document, whether any temporary measures apply, who the parties are, if the document needs to be witnessed and you intend to do this remotely, ensure the applicable requirements are met. And finally, if the receiving entity is a Commonwealth entity, ensure any technical requirements of the Commonwealth entity are satisfied. And that was all I was intending to say today. So, is Gordon still around? If not, I'm happy to take any questions if anyone would like to ask any. Otherwise, thank you very much for attending. Okay. Well, thank you very much, everyone. We will see you for the next webinar in a couple of weeks.